Dispute settlement. Jurisdictions of the different agencies. Bureau of Labor Relations. Original jurisdictions appeal to DOLE Secretary. Appellate jurisdiction decisions shall be immediately executory upon issuance of entry of final judgment. Jurisdictions, inter-union conflicts, and tri-union conflicts, all disputes, grievances, or problems arising from labor management relations in all workplaces. Complaint involving federations. Compromise agreements. If voluntarily agreed upon by the parties with the assistance of the BLR or the regional office of DOLE, the only time NLRC or any courts can assume jurisdictions over issues involved therein. Power to issue subpoena. When relevant to a labor disputes under its jurisdictions, either at the request of any interested party or at its own initiative. Privileged communications. Informations and statements made at conciliation meetings shall not be used as evidence in the NLRC. Conciliations and similar officials shall not testify in any court. Appeal within 10 days to the DOLE Secretary. Grounds: grave abuse of discretion, gross incompetence. Jurisdictions of labor arbiters. ULP termination disputes, claims for wages, rates of pay, hours of work, and other terms and conditions of employment. Claims for actual, moral, exemplary, and other forms of damages. Cases arising from prohibited activities during strikes. Cooperatives. Terminations of members of cooperatives is not cognizable by the labor arbiters. Labor arbiters has jurisdictions over illegal dismissal cases involving employees of cooperatives. Labor arbiters does not have jurisdictions over intra-corporate disputes, cases involving corporate officers, cases involving GOCCLs with original charters, cases involving entities immune from suit, local water district actions based on tort. Jurisdictions of the NLRC. Original jurisdictions. Number 1 is injunction in ordinary labor disputes, injunction in strikes or lockouts, certified labor disputes causing a strike or lockout, exclusive appellate jurisdictions. Number 2, all cases decided by the labor arbiters, cases decided by the DOLE involving recovery of wages not exceeding 500,000, jurisdictions of the POEA, cancellations, suspensions of license or of authority, disciplinary actions against OFWs, appeal to Secretary of DOLE within 10 calendar days, appeal to NLRC within 10 calendar days, violations of overseas employment contracts, disciplinary cases filed against overseas contract workers, the jurisdictions of DOLE regional directors, visitorial power, columns not exceeding 500,000, violations of the constitutions and bylaws, inter-union and intra-union disputes, jurisdictions of the NCMB, conciliations, mediations, and voluntary arbitrations cases. Procedure. Article 221, Technical Rule, not bending and bending prior resort to amicable settlement. Article 222, Appearances and Fees. The rules of evidences prevailing in courts of law shall not be controlling. It is the spirit and intentions of the code which shall be used as reasonable means, without regard of technicalities of law and procedure, all in the interest of due process. Voluntary appearance of the lawyer amounts. Payment of docket fees is not required. Appeals. Article 223, Appeal. In Article 224, Executive Decision, Orders, or Awards. Appeals of LA decisions. Appeal from the decision of all the labor arbiters is brought by ordinary appeal. Way of special civil actions of certiorari grounds. prima facie evidence of abuse of discretions on part of labor arbitrators. The decision's order or award was secured through fraud or coercion. Pure questions of law raise serious errors at request monetary award employer. Appeal involving monetary award. No monetary award remedy in case of failures to post bond. Motions to reduce bond does not toll the running of the period. In order to effectively stop the running of the period within which to perfect the appeal, the motions to reduce bond must comply the requisites that filed within the reglementary period based on meritorious grounds, a reasonable amount of bond, reinstatement of pending appeal. If reinstatement is ordered in an illegal dismissal case, self-executing with no need for a writ of executions, appeal of voluntary arbitrators' decisions. Appeal of voluntary arbitrators' decisions, denial of applications for registrations of a union, cancellations of registrations of a union, decisions of the BLR rendered in its original and appellate jurisdictions. Appeal of regional directors' decisions under Article 123. Appeal to NLRC. Thank you.